Shoes. Recorded live.
Welcome, everyone, to this Wednesday, December 22nd, 2010 edition of Money Banking and Trust by Moving Titles and Commerce. Welcome to the Free American Show, who sponsors this. This Wednesday, we're going through the Lewin book, and we're picking up on, what page is it? 797 of the book, and section 39. Page 797 of the Lewin book, section 39. So take notice and acknowledgement with agreement that this show and or documents is private, not to be construed or relied upon as being legal advice for any individual legal situation or employed for making a legal decision. And you will not use any of this information for making a legal decision or performing a legal procedure, and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and our documents are for academic informational purposes only, to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of the therein reference, and has no interest in any issue referenced to it therein, is not a party to this or any action arising from, and is only acting as an authorized capacity as liaisons to communications between the parties. By reading or using this information, you acquire knowledge and agree that you are not a client of Christian Walters. These documents and show recordings are incomplete and void without this notice agreement being attached herein by reference, and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million per stultification or impairment per Christian Walters' discretion. Thank you for your understanding. Okay. We're on starting at number 39. We're in the section of General Powers of Trustees. Number 39, where consent of bankrupt tenant for life reacquired. Where there's a power of advancement with the consent of the tenant for life, and the tenant for life becomes a bankrupt, his power of consenting is not extinguished, but can only be exercised with the consent of his trustee in bankruptcy, acting under the direction of the Court of Bankruptcy. Number 40, general power of advancing tenant for life. Where trustees has had a power to apply in monety of trust fund for towards the preferment or advancement of the tenant for life, or otherwise of his benefit, in such a manner as they should in discretion think fit, it was held that they might apply the monety in payment of the debts of the tenant for life, the interest of which absorbed nearly a whole of his income, and the principal which he was unable to pay out of his own resources. So a power of applying the capital for the benefit and advancement of the world of the tenant for life, coupled with the words showing that the power of advancement was a large one, has been held to justify applications of the trust funds for the benefit of the tenant for life, which were not strictly advancements. 41, debts barred by the statute of limitations. An executor has never been held responsible for paying a debt due and owing from the testator's estate, the remedy for which has been barred by the statutes of limitations, and upon the same principle, he may retain his own debt through, though barred. But an executor would not be at liberty to pay such a debt after a decree for administration of the testator's estate, for from that time any other creditor or even a legatee, specific, pecuniary, or residuary, may plead the statute in taking the accounts, except to the debt of a plaintiff in a creditor's suit, to which the debt the defendant, the executor, did not plead the statute by his statement of defense, and on the basis of which the decree has been made. If after decree neither the executor nor the parties beneficially interested before the court pled the statute, the court will not set up the statute on behalf of the absent parties. But if the executor omits to plead the statute, it is at his own risk. 42. Promise of subscription. It sometimes happens that the deceased made some promise, written or verbal, to subscribe a certain sum for the promotion of some charitable or public use. If nothing has been done in consequence of such promise, the executor or administrator must treat the promise as voluntary and therefore null. But if other persons have acted on the faith of the promise and would suffer a loss if it were not observed, the executor or administrator is convinced would be justified in giving it effect. 43. When trustee may apply under Settled Estate Act. If an estate is vested in trustees and there is not for the time being any beneficial owner of the rents and profits, the trustees are the proper persons to apply to the court under the 23rd section of the Settled Estates Act, 1877, to exercise the powers conferred by the Act. Number 44, power to release or compound debts. A trustee may, under circumstances, release or compound debt. But if the trustee release or compound a debt without some sufficient ground and justification, or if he sells the debt for a grossly inadequate consideration, he will clearly be answerable to the City Key Trust for the amount of the divest event. 23 and 24, Victoria, Sections 145. Executors under wills executed after the 28th of August, 1860, whereby Lord Cransworth Act, expressly authorized to accept any composition or any security, real or personal, for any debts due to the deceased, and to allow any time for payment of such debts as they should think fit, and also to compromise, compound, or submit to arbitration all debts, accounts, claims, and things whatsoever relating to the estate of the deceased, without being responsible for any loss to be occasioned thereby. Next, 44 and 45, Victoria, Sections 41. But this section has been repealed and has been in its place supplied by the Conveyancing and Law of Property Act, 1881, which as to executorships and trusts constituted or created either before or after the commencement of the Act, provided by Section 37 that 1. An executor may pay or allow any debt or claim or on any evidence that he thinks sufficient. 2. An executor or two or more trustees acting together, or a sole acting trustee where by the instrument, if any, creating the trust, a sole trustee is authorized to execute the trust and powers thereof, may, and if as he thinks fit, accept any composition or any security, real or personal, for any debt or for any property, real or personal, claim, and may allow any time for payment of any debt, and may compromise, compound, abandon, submit to arbitration, or otherwise settle any debt, account, claim, or thing whatever relating to the testator's estate or to the trust, and may execute and do all such releases and things as it seem expedient, without being reasonably responsible for any loss occasioned by anything done in good faith. As regards trustees in section is subject to any contrary intention expressed in the instrument creating the trust. In exercising the powers of this section, in a case where there are several trustees, it is conceived that all the trustees must act together, except in cases in which, independently of this section, a majority of the trustees are by law capable of binding the majority. The object of the section was not to enable some of the trustees to act without the concurrence of their co-trustees. It will be observed that the power of this section are only exercisable by a sole acting trustee in cases where the sole trustee is by the instrument, if any, creating the trust, authorized to execute the trust and powers thereof. But by the 38th section, as to the trusts created by instruments coming into operation after the 31st of December, 1881, any trust or power vested in two or more trustees jointly, and in the absence of a contrary intention to the instrument creating the trust or power, may be exercised or performed by the survivor for the time being, and it seems to follow that in the case of trust falling within the section and the powers of Section 37 may be exercised by a sole surviving trustee. This section has largely extended the powers of executors and trustees, and it would seem that in future the only question will be whether the executors or trustees have acted in good faith in relation to any of the matters authorized by the section. Next, discretion of executors. Independently of the section, executors have a fair discretion whether they will press a debtor for payment and will not be held liable for willful neglect or default if they have exercised their discretion honestly and fairly and in some time to the debtor, although loss may result from the delay. Next, 45, settlement with one residuary legatee. Executors and trustees of a will, when they have discharged the funeral and testamentary expenses, debts, and legacies, may come to the final account with one of the residuary legatees separately, and if such residuary legatee be paid only what is his fair share at the time, he will not be made to account to the other residuary legatees if the undistributed parts afterwards become depreciated or lost. Next, 46, appropriation of residue. Next, 46, appropriation of residue. When a residue consists of a great variety of securities, the question arises whether the trustee, in the absence of the special power, can virtue officii, where infants are concerned, divide the residue by appropriating some securities to one residuary legatee and the other securities to another, but so that the distribution is fair, one account according to the market price of the day of the funds so appreciated. Courts can now make such an apportionment, for in suit guardians ad litem for the infants are apportioned and are held on their behalf to protect their interests. But out of court, where the voice of the infants cannot be heard, it would be unsafe for trustees to make such an apportionment on their own responsibility. However, where trustees are directed to invest the infant's share on a particular securities, they might accept securities of a nature prescribed at the market price, as the transaction, when resolved, would be the payment of so much money, and the investment of it by the trustees in requisite securities. Where there are no special powers, the trustees should turn the whole of the irregular species of property into money and divide the proceeds. Next, 45, release of equity of redemption. Trustees of an equity of redemption of lands mortgaged for more than their value may, it is concerned, release the equity of redemption to the mortgagee rather than be made defendants to a foreclosure suit, the cost of which, so far as incurred by themselves, would fall upon the trust estate. 46, whether trustees, mortgagees can release part of the land in mortgage. Where trustees are mortgagees, they are so often requested to release part of the land from the security in order to enable the mortgagor to deal with it for his own convenience. Where the value of the land is not excessive as compared with the debt, it would, of course, be a gross breach of trust to deteriorate the security. But suppose the value of the part left in the mortgage to be, say, double the amount of the debt. May the trustees release the residual? It is presumed that trustees can never justify the abandonment of any part of the security on the mere ground of consulting the convenience of the mortgagor, and they must be prepared to show that the act was calculated under the circumstances to promote the interest of the City Key Trust. But if the mortgagor be ready to pay off the mortgage on a transfer of the security, unless the trustees will consent to release, and the existing mortgage, even when confined to the narrow parcels, is clearly beneficial one and the value still abundantly ample, the trustees would surely incur no responsibility by acceding to the arrangement. The prevailing opinion of conservators appear to be that the trustee have a power of investing on a mortgage and a varying security, which a power of investing on a mortgage implies. The transaction will be considered as tantamount to the repayment of the mortgage money and reinvestment of the trustees on a mortgage of the hereditaments retained as a security, and that the purchaser for the released hereditaments is not bound to see the sufficiency of the new security, or that the acceptance of the new security does not involve a breach of trust. 47. Whether bound to consolidate mortgages. It is conceived that although trustees holding independent securities from the same mortgagor may have the right to consolidate them, it is not imperative upon them to do so, but they may deal with the securities independently or allow one or more of them to be redeemed without incurring any liability for loss which may arise from the subsequent depreciation in the other securities. They should, however, satisfy themselves before parting with any of the securities or allowing any of them to be redeemed, that the margin of value on those which are retained is then sufficient to justify a present advancement of the amounts remaining due to the trustees upon such securities. 48. Discharge of mortgage on settled estates. Trustees of a settled estate with the power of sale and reinvestment may, it is conceived, sell part of the estate to pay off a mortgage affecting the estate, though not mentioned in the settlement. For this is in substance is a reinvestment a fortiori, and if the trustees have a power of investing on real securities until the purchase can be found, they can sell part of the estate and apply the proceeds in taking a transfer of the mortgage provided as adequate security. 49. Sale of limited interest. Trustees for sale of limited interest in an estate as a remainder, or if the aliquot part of the estate is undivided 1/4, may concur with other parties in the sale of the whole estate for one entire sum, and may agree afterwards as to the apportionment of the purchased money, and if the parties cannot agree, an apportionment will be made by the court, but otherwise it would not be intelligible principle upon which the appointment can be made. Reimbursement of expenses on account of trust. A trustee may reimburse himself a sum of money bona fide advanced by him by the benefit of the City Key Trust, or even of his own protection in the execution of his office. For, as a rule, said Lord Chancellor King, that the City Key Trust ought to say the trustees harmless, so within the reason of that rule, when trustees has honestly and fairly, without any possibility of being a gainer, laid down money which the City Key Trust has discharged from being liable for the whole money lent, or from the plain and great hazard of being so, he ought to be repaid. Next, 51. Power of trustee for sale to clear the estate. The trustee for sale has been held to be justified in applying part of the purchased money and paying off a charge without satisfaction of which the purchaser refused to complete, and which the trustee was professionally advised and still subsisting, though the charge itself was open to doubt. 52. Power to grant lease. Trustee of lands may grant a reasonable husbandry lease and in the fair management of the estate, but he has no power to devise where it was simple trust and the City Key Trust in possession, except he do it with the City Key Trust concurrence. In prima facie, a trustee for sale would not be justified in granting a lease, and although a trustee may grant a farming lease, it does not follow that he could grant a mining lease, for the latter is pro tanto and destruction of the corpus. Trustees having power to grant leases to any person or persons may lease to a limited company. by Section 43 of the Agricultural Holding England Act, 1883, when by the instruments a lease of a holding is authorized to be made, provided that the best rent or reservation of the nature of rent is reserved on a lease to the tenant of the holding, it shall not be necessary in estimating such rent or reservation to take into account against the tenant the increase, if any, in the value of such holding arising from improvements made or paid for or by him. Powers of directors. The manager of a trading company or partnership have no power, whatever the necessity of the case, to borrow money beyond the capital prescribed by the act or deed of settlement, and as to give the lenders a remedy against the company. And where without any special authority being conferred by the deed of settlement, money is borrowed for launching or enlarging the concern, the managers, though made to pay upon their personal liability under the contract, have no remedy over against the other members of the company. But every business must be carried on at either a profit or a loss, and as the members of the company take the profit, they must also bear the loss, and therefore of the managers incurred debts or expenses by employing labor or ordering goods in the ordinary course of business, or borrow money and apply it to these purposes, they must be indemnified in equity by other members of the company. 54. Trustees' shares. Trustees of shares in an unlimited banking company have no power, unless specially authorized by the settlement, to accept new shares allotted to them through the issue at a premium. 55. Enfranchisement. By 15 and 16 Victoria 51, Sections 32, trustees of copyholds were employed on enfranchisement to charge the expenses on the estate and franchise, but this section was repealed by 21 and 22 Victoria, subsection 94, Section 2, and reenacted in effect by the 21st Section, which authorizes all persons in franchising to charge the expense with the consent of the commissioners on the estate. Any enfranchisement of a trust estate should have been made to the trustees who has the legal estate and not to the Seti Key Trust. Enlarging long-term into fee. By the Conveyancing and Law of Property Act, 1881, trustees in receipt of the income and right of a long term or having term vested in them in trust for sale may exercise the power of the act for enlargement of the term into a fee simple. The estate in fee simple so acquired is to be the subject to all the same trust powers, executory limitations over rights and equities as the terms would have been subject to if it had not been enlarged. But where such whole leaseholds have been settled in trust by reference to freeholds, so as to go along with them as far as the law permits, and at the time of the enlargement, the ultimate beneficial interest in the term has not become absolutely indefeasibly vested, the estate in the fee simple is, without prejudice to any conveyance of value previously made, to be conveyed and settled and devolved in the same manner as a freeholds. Compensation for agricultural improvements. By the Agricultural Holdings Act in England, 1883, a tenant who has made on his holding certain improvements specified in the Schedule to the Acts is entitled to quitting his holdings at the determination of his tenancy to compensation from the landlord from which improvements to be ascertained as provided by the Act. But by Section 31, where the landlord is a trustee, the amount of the compensation is not to be recoverable from him personally, but is to be charged on and recoverable against the holding only. And by Section 42, subject to certain provisions as to the Crown, duchy, ecclesiastical, and charity lands, a landlord, whoever may be in his estate or interest in his holdings, may give any consent, make any agreement, or do or have done to him any act in relation to the improvements in respect to such compensation as payable under the Acts. And if he were, in the cases of an estate of inheritance, owner thereof in fee, and in case of the leaseholds possessed of the whole estate in the leasehold. 58. Powers of majority of trustees. general powers allowed to trustees must, in private trust, be exercised by all the trustees of the joint body, but in charitable or public trust, a voice of the majority will bind the rest. And in certain cases, the majority can give effect to their resolution by passing the legal estate under a statutory power. 59. Cases of suit instituted and a decree made. Powers assigned in the preceding pages to trustees must be taken subject to qualifications that if the suit has been instituted for the execution of the trust and a decree made, the powers of the trustees are then so far as paralyzed at the authority of the court, must sanction every subsequent proceeding. Thus, the trustees cannot commence or defend any action or suit or interfere in any other legal proceeding without first consulting the court as to the propriety of so doing. A trustee for sale cannot sell, the committee of a lunatic cannot make repairs, an executor cannot pay debts or deal with the assets for the purpose of investment. But an executor as to a chattel, not the subject of the suit specifically, can after a decree give a good title to a bona fide purchaser, not having actual notice of his less pendants, and is presumed that he can equally, where there is no receiver appointed, sign a valid receipt for any part of the testator's personal estate, but where the administration action has been heard on various consideration and no subsequent further consideration has been reserved, but the general liberty to apply has been, trustees may exercise their powers without obtaining sanction of the court. Number 6, the case of suit and no decree. An action in which a writ merely has been issued is distinguishable from one in which a decree has been made, for until a decree the plaintiff may demise his action at any moment, and should he do so, the progress of the trust may be arrested for no purpose. I'll read that again. Let's see. An action in which a writ merely has been issued is disguisable from one in which a decree has been made, for until a decree the plaintiff may demise his action at any moment, and should he do so, the progress of the trust may be arrested for no purpose. However, even in this case, the trustee cannot be advised to act without first consulting the court, and if by acting independently of the court expenses be incurred, which might have been avoided had the trustees applied to the court, they may be made to bear them personally. 61. Duty of executor after institution of suit. Even after a decree made, the trustee is not absolved from the duties imposed by his office. Thus, after a decree in an administration suit, an executor is held liable for having allowed a policy of insurance to drop without any sufficient reason. Next, Section 2, the special powers of trustee. Special powers. Upon this branch of our subject, we shall consider first the different kinds of powers, secondly, the construction of powers, thirdly, the effect of disclaimer, assignment of the estate and survivorship among the trustees, fourthly, the control of the court over the exercise of powers, and fifthly, the restriction on the powers of trustees imposed by the Settled Lands Act. I, of the different kinds of powers. Number 1, powers legal and equitable distinguished. In applying the doctrine of powers to the subject of trust, it may be useful to regard powers as either legal or equitable. Legal or equitable. The former, the legal, such as operate upon the legal estates and so are matter of cognizance in courts of common law, and latter, such as affect an equitable interest only and fall exclusively under the notice of court of equity. Thus, hence to be limited to the use of A for life remainder to B and his heirs, and a power operating under the statutes of uses to given to C. The execution of the powers works a conveyance of the legal estate, but if lands be limited to the use of A, and his heirs upon trust for B for life, and after his death for C and his heirs, and the power not operating under the statute of uses, be given either to the trustee or to the city key trust. The execution of such power will then have no effect at law, but will merely serve to transfer the beneficial interest in equity and may therefore be regarded by the name of an equitable power. Very interesting. Very interesting. And I would say that section there should be reviewed again for better understanding. Continuing on, number 2. Equitable powers, whether annexed to the estate or simple collateral. An equitable, and then same as the legal power, may be either annexed to the estate or simply collateral. But whether it shall be taken as one or the other will depend on the question whether the donee of the power be possessed of the equitable, that is, of the beneficial interest, or not. Thus, where the testator devised an estate to his sister and her heirs forever, upon trust to settle it on such a decedent of the testator's mother as his sister should think fit, and the divisee having been married, the question was raised whether the execution of the power by her, as she was under a coverture at the time, was to be considered as valid. Lord Hardwicke held that it has been a power without an interest, that is, without any beneficial interest, and could therefore be executed by a fem covert. On the other hand, whether the legal estate was devised to trustees in fee upon trust for an infant, fem covert, for her sole and separate use during her life, and upon trust to permit her by the deed of a writing executed in the presence of 3 or more witnesses, notwithstanding her coverture, to dispose of the estate as she would think fit, and the testator died, leaving the fem covert his heir at law, and she, during the continuance of the coverture and intimacy, exercised the power by will, Lord Hardwicke, upon question whether the power had been duly executed, observed that this was a power coupled with an interest, and which was always considered different from naked powers. It was admitted that if this execution was to operate on the estate of the infant until it might not be good, now this was clearly so, for as had the trust in equity for life, with their trust of the inheritance in her in the meantime, so that this was directly a power over her own inheritance and could not be executed by an infant. Number 3, exercise of power by infant. In the case of the personal estate, however, an infant may exercise a power in gross, thus where under a marriage settlement an infant, fem covert, to whom the income of the settled property was given for her life or for her separate use, had in the events which happened a general power limited to her by appointing the trust funds after her death and subject to the interest of the husband by deed or will, and she exercised the power by deed and died an infant, and it was held by the late M.R. and confirmed by the Court of Appeals, Disententi Cotton, L.J., that the power was well exercised, and the M.R. observed, if it is clearly settled that the first class of powers simply collateral, can be exercised by an infant, there can be no reason why the second class of powers in gross, should not be so exercised when the exercise cannot affect the infant's interest. I can see no sufficient distinction between the two cases. It can make no difference that the infant has some interest under a settlement, so long as the interest cannot be affected by the exercise of the power. Number 4, bare powers and powers coupled with trusts. Again, powers, in the sense in which the term is commonly used, may be distributed into mere powers and powers coupled with the trust. The formers are powers in the proper sense of the word, that is, non-imperative but purely arbitrary powers, which the trustee cannot be compelled to execute, and which, on failure of the trustee, cannot be executed vicariously by the court. The latter, on the other hand, are not arbitrary but imperative, have all the nature and substance of a trust, and ought rather, as Lord Hardwicke observed, be designated by the name of the trust. It is perfectly clear, said Lord Eldon, that where there is mere power and the power is not executed, the court cannot execute it. It is equally clear that whether the trust is created and the execution of the trust fails by the death of the trustee or by accident, this court will execute the trust. But there are not only a mere trust and a mere power, but there is also known to this court a power which the party whom it has been given is entrusted and required to execute. And with regard to that species of power, the court considers it as partaking so much of the nature of the quality of the trust that if the person who has the duty imposed upon him does not discharge it, the court will, to a certain extent, discharge the duty in his room and place. 5. Strict powers and powers directory. Again, powers have been dealt with the courts as either a strict or a directory character. The power such as only arise under the exact circumstances prescribed by the settlement. The latter, such as being merely monitory, may be taken with a degree of latitude. Thus, where an advowson is vested in a trustee for a trust to elect and present a fit person within 6 months from the incumbent's decease, it was considered that the clause was directory, and that the trustees might equally elect and present, although the period had elapsed. So where 6 trustees were empowered when reduced to 3 to substitute others and all died but one, it was held competent to the sole survivor to fill up the number. And where the case of 21 or 25 trustees, the direction was that when reduced to 15, the survivors should nominate, and it was determined by the court that although 17 remained, the survivors were at liberty to exercise their power, but that when reduced to only 15, they were capable to do so. 6. Charity. These were cases of charitable trust in which it seems a greater latitude of construction is allowed, but in other cases where the trusts were not charitable, the estates were devised to trustees upon trust to sell with all convenient speed, and within 5 years after the testator's decease, it was held that these words were directory only, and that the trustees could sell and make a good title along the 5 years had expired, although the 5 years had expired. 2. We proceed to consider the construction of powers, as the powers of trustees are regulated by the doctrines of applicable to the powers in general, as the admirable treatise of Lord St. Eldon's is in every one's hands. We shall advert only to some cases of most frequent occurrence. Number 1, power to A and B and their heirs. If a power be given to A and B and their heirs, it is perfectly clear that although the limitation of estate in such terms would so vest in the grantees that they may convey it to a stranger, and the survivor devise it, the power is not to be construed as intended in like manner to be assignable and divisible. Chief Justice Wilmot's opinion upon the subject of a power where it was given personally, the unaccompanied by any estate to A and B and their heirs, Lord Chief Justice Wilmot observed, it is asked what must become of the power upon the death of one of the trustees. It must be considered as a tenancy in common. Had the words been their several and respective heirs, it would have been clear, and the common parcel, according to the common apprehension of mankind, when an estate is given to 2 men and their heirs, no one not illuminated with the legal nature of joint tenancy should ever conceive the estate to go to the heirs of the survivor. It is equivalent to say, with consent of both while they live, but when one dies, that the consent shall devolve to his heir, and the heir of the deed trustee shall consent as well as the surviving trustee. One may abuse the power. I will supply the loss by one of his heirs, and the loss of both by the heirs of both. But this was where A and B had a mere power, for A and B are trustees of an estate limited to them and their heirs, and the powers constitutes an essential part of the trust, and it will pass with the estate to the survivor. Next, Townsend versus Wilson. In Townsend versus Wilson, a power of sale was given to 3 trustees to preserve contingent remainders and their heirs, and it was directed that the money to arise from the sale should be paid into the hands of the trustees or the survivors or survivor of them, and the executors, administrators, or assigns of the survivor, and there was a power of appointment of new trustees with a direction that such appointment should take place as often as any of one or more of the trustees should die, etc. One of the trustees died, and it was determined by the court of the Queen's Bench that the survivors alone were incapable of exercising the power. Lord Eldon was dissatisfied with the decision and asked, did the court of Queen's Bench consider that the surviving trustees and the heirs of the deceased trustees were to act together? For it was one thing to say that the survivors should not act until another was appointed, and the different thing to say the heirs of the deceased trustee could act in the meantime. But his lordship so far bowed to the authority of the decision that he refused under similar circumstances to compel the purchaser to accept the title. In Townsend versus Wilson, the trustees had not the fee, and the power was not to be executed as part of the trusteeship, and there was therefore no authority against the execution of the trust by surviving trustees. Indeed, where the estate was devised to 3 trustees and their respective heirs, upon trust that they had their respective heirs should sell, the word respective was rejected for surplusages, and it was held that the survivors could make a title. 2. Hewitt versus Hewitt. A testator devised an estate to 4 persons to use in strict settlement with the power to the tenants for life, with an actual possession to cut such trees as for devised to use, or the survivor or survivor of them, omitting the words and the heirs of the survivor. Should direct, all the trustees being dead, the question whether the power was gone. Lord Henley held that upon the construction of the will, the testator intended the power to be coextensive with the life estates, and that the trustees were impressed with the supervisors only to prevent destruction, and that the office of the trustee was not personal, but such as might be executed by the court. Here, therefore, considered the power as sustaining, and referred to it to the master to inquire as what the timber was fit to cut. The court, therefore, did not regard the authority of the trustee as a mere power, but as a trust. 3. Power to trustee as his assigns. Where the discretionary legal power is expressly limited to A and his assigns, the grantee or divisee of A and even claimant under him by operation of law as an heir or executor may exercise the power, but in a trust, if an estate be vested in a trustee upon trust that he, his heirs, executors, administrators, or assigns shall sell, etc., and introduce the word assigns, will not authorize the trustee to assign the estate to the stranger, nor, if the assignment be made, will the stranger be capable of exercising the power. 4. Power given to a mortgagee. In a mortgage with a power of sale limited to the mortgagee, his heirs, executors, administrators, and assigns, the intention is that the power should go along with and be annexed to the security, and therefore, if the mortgage be assigned to a stranger and the legal estate be conveyed to the stranger or trustee for him, the stranger, along with the concurrence of the trustee, can give a good legal and equitable title, and even if the mortgage be made to A and B to secure a joint advance, and the power of sale and signing receipts be limited to A and B, their heirs and assigns, it has been held that as the power and security were plainly meant to be coupled together, the security inures to the benefit of the survivors, the advance being joint one, and the survivor may also sell. 5. Power indicating personal confidence to A and his executors. If a power indicating personal confidence be given to the trustee and his executors, and the executor of a trustee dies having appointed an executor, the latter executor, although by law the executor not only of his immediate testator, but also of trustees, will not, if it is said to be considered to the purpose of the power, for a matter of personal confidence is not to be extended beyond the express words and clear intention of the settlor, and in the case, the settlor may have meant the power to be exercised exclusively by the executors whom the trustee had himself named, and not by a person who is executor of the trustee by operation of law only. Thus, however, it is a narrow construction that the liberty of modern times may not improbably hold that, if the power be given to executors, the settlor must be taken to have completed, generally, even one whom the law invests with that character. 6. Power to executors and trustees. A power limited to the executors or sole sons-in-law may be exercised by the survivors so long as the plural number remains. And if a power be limited by a number of trustees, we may reasonably conclude that whether any estate or not, that is, whether the power be adjunct to the trust or collateral to it, and may be exercised by the surviving trustees. And the power given to the executors will, if annexed to the executorship, be continued to the single survivor. And so a power given to the trustee will, as annexed to the estate and office, be exercisable by single survivor, but it cannot be exercised by the one trustee in a lifetime of the other who has not effectually disclaimed. It has been said that if the power to vary the rights of parties be communicated to the trustees for the time being, it cannot be exercised by a single trustee. And where there was a trust for sale, but no sale was to be made without the consent of the testator's sons and daughters, and he left 7 sons and daughters, and one died, it was held that the sale with the consent of the survivors was too doubtful a title to be specifically enforced. Number 7, power to trustee and survivors. A discretionary power to 4 trustees and the survivors of them cannot, it seems, be executed by the last survivor, for though a power of trustees may, in general, be held to survive, an intention to the contrary may be fairly inferred. The settlor may be supposed to have said, I repose a confidence in any 2 of the trustees jointly, but in neither one of them individually. Next, to trustee and survivor. But if a power be limited to 4 trustees and the survivor of them, it may well be argued that on the death of one, the power may still be exercised by the survivors, for there can be no valid reason why the person who trusted the 4 jointly and each of them individually should refuse to repose the confidence in the survivors for the time being. Number 8, Trower versus Knightley. In the case before Sir J. Leach, a testator devised an estate to trustees upon trust as for one motive for A, for life, remainder to her children at 21, and as the other motive for B, for life, remainder to her children at 21, and gave the trustee a power of sale during the continuance of the trust. A died and her children attained 21, and the question was whether the trustees could, under the power, sell the whole estate, and the children of B being infants. The Vice Chancellor held that if the children of A could call of the present conveyance of the motive for the would have been an effect of depriving B and her children of the benefit of the power of sale and also the leasing power given to the trustee, for that an undivided motive could not advantageously be sold or leased, and that the testator must have meant to continue the powers of ownership to the trustee until there was owners competent to deal with the whole estate. 9, power during the continuance of a trust. But if a power be given to a trustee to be exercised during the continuance of the trust, it cannot be exercised after the time when the trust ought to have been completed, though from the delay of the trustees it happens that the trust has not in fact been executed. 10, power ceased when settlement is at an end. And though the power not be confined expressly to the continuance of the trust, yet the power is gone when the object of the trust had been fully exhausted, but not before. But the mere fact that the beneficial interest of the beneficiary, the beneficial interest in the property having become vested in persons, all of whom are sui juris, will not put an end to the power if on the construction of the instrument creating the power the intention appears that it should still be exercisable and the power in creation was not obnoxious to the rule against perpetuities. Next, within what time power must be exercised? If a power of sale be given in general terms, the question arises within what limit of time it must be exercised. This will depend on the nature and limitations contained in the will or settlement, for when, by reason of expiration or seizure of the limitations, the absolute interest comes into existence, the power is considered to be at an end, and for the settlement to be valid, the limitations must become absolute within the period allowed by the rule against perpetuities. A power which is to continue in existence until the interest are absolute will also be valid. If the settlement contains the first instance absolute limitations of interest, a power of sale given for the purpose of devise a division among the beneficiaries will not be invalid, but it must be exercised within reasonable time. Number 11, joint powers. Powers given to trustees when exercised by them jointly, but an act by one trustees will sanction, with the sanction and approval of a co-trustee, will be deemed the act of both. 12, contract for lease by tenants for life carried out, where a power of leasing was given to a legal tenant for life, and after the death of trustee during the minority of the legal tenant entail, and the tenant for life entered into a contract to grant a building lease, but died before the lease was granted, it was held that the trustees had power to effectuate the contract of the tenant for life by executing a lease. 13, moral considerations. Trustees in the exercise of their powers must act bona fide and impartially for the benefit of the Sedekey Trust, that is, persons claiming under the settlement, and must not deviate from the terms of the trust for moral consideration or seek to do that they may think right if in exercise of their trust. If in excess of their trust. Number 3, of the effect of disclaimer, assignment, and survivorship of the estate. First, of disclaimer. Number 1, effect of disclaimer upon powers. If a power be given to several trustees and one of them disclaims the trust, the power may be exercised by the continuing trustees or the trustee. In Hawkins versus Kempt, a purchaser at first objected that the acceptant trustees could not exercise the power, or not without the appointment of a new trustee in place of the trustee who had disclaimed, but the point was afterwards abandoned by the purchaser's counsel as untenable. And the late Vice Chancellor of the England in a subsequent case observed, I have always understood ever since the point was decided in Hawkins versus Kempt, or rather was, as the judges said, in that case, properly abandoned by the defendant's counsel as not capable of being contended for, that where 2 or more persons are appointed trustees and all of them except one renounce, the trust may be executed by the one. Next, Adam versus Totten. It is directed by the decision of Sir J. Leach to the same effect. A testator had devised an estate to A and B upon trust to sell and apply the proceeds amongst his children, and declared that the receipts of said A and B should be sufficient discharges. A renounced, and Sir J. Leach, after having taken time to consult with authorities, said, it being now settled that the devise to A, B, and C upon trust is a good devise to such of the 3 as accept the trust, it follows by necessary construction that the receipt of the trustees to be intended the receipt to those who accept the trust. 2, powers to trustees or executors. If the power be not given to the trustees by name, but the trustees or executors, it is clear a fortiori that if one disclaim, the acting trustees or executors may exercise the power. 3, by Conveyancing Act 1882, Section 6, which applies to powers created by instruments coming into operation either before or after the commencement of the Act, a person to whom any power, whether coupled with an interest or not, is given may by deed disclaim the powers, and after disclaimer shall not be capable of exercising or joining in the exercise of the power. On such disclaimer, the power may be exercised by the other or others, or the survivors or survivor of the others, of the persons to whom the power is given, unless the contrary is expressed in the instrument creating the power. But this section does not authorize the trustee to disclaim a particular power so as to vest the exercise of it in his co-trustees while he continues a trustee for other purposes. Number 4, renunciation. It has been held in Ireland that the renunciation by one executor by an instrument under seal of the office of executor operates as a disclaimer under this section of powers annexed to the executorship. Secondly, of assignment. Number 1, I think we'll stop there on page 821, and we'll pick up on the second leave of assignment, number 1, effective assignment of estate, on page 821 next time. So let's open it up for questions. I forget what to do. Raise star 8, I believe it is, to raise your hand and get in the queue line. I believe it's star 8. Press star 8 to get in line. Raise your hand. Star 8. Star 8 to raise your hand, get in the queue line, ask a question, state your name, where you're from. Anybody have a question? Star 8. Star 8 to raise your hand. Okay, you're unmuted. Go ahead.
Hello?
Yes,
Hello?
hello. Who's this?
This is Mike in Chicago.
Hi, Mike.
Hi. Hi, Christian. Christian, I've got basically one question, or rather, I want to ask you for the help to help me find the resources. And kind of, for me, to really understand entity, I have to take a step back, and I realized that I have to study banking theory a little bit. I found good resources of it, but during doing this, I realized that I need to find the source of this notion, which I believe is a basic notion, and I share this conviction that all funds are created out of our signature. But what's troubling me that if I would like to prove to anyone that it's a truth, I don't know where to reach to really show it to someone else. And I would like to ask you to direct me to the resources and studies, because otherwise I feel that I cannot really move that too much forward.
You mean your signature creates funds, you mean?
Yeah, the ultimate value is in our signature, that we can, use our signature, that all debts are created out of our signatures, and all the funds, and we can extinguish the debt using our signature as an equitable asset.
Yeah, I would start with the federal publication, Modern Money Mechanics. That article there by the Feds shows how the Feds creates money out of thin air. And
okay.
what do they create your money out of thin air with?
I've been through it. Okay. It's good source.
Connect to get that understanding. There's too many little coincidental things that are like little grains of nuggets of gold that you're going to have to pile them up in a pile, and then pretty soon you keep piling up this pile, and it gets big enough that, this becomes a big hill and a mountain. Mm-hmm. So it's the connecting of the dots of many little things. But most people are looking for a mountain of one particular instance that is the switch that they're going to rely on that convinces them that that's so. And how they hide it is they've broken that mountain down into many, many fine little dots, and you have to connect the dots. And not many people are willing to connect the dots because you got to do the research and the study. And
right.
they say that, most people will not do that. They're looking for the mountain, the one big mountain they can say, oh, yeah, that's it right there. You can't rely on that because there is none. It's the little dots that you got to do the research and pile it up. It's just like the Federal Reserve notes. They got codes on those numbers in the beginning, and they're coded to the birth certificates. Now, this is done on many other people before me their research, and you'll have to go back and dig up how they've come about these things. But, there's too many little things that mount up that they just keep pointing to this mountain.
Right. I see what you're saying. It's like entity. Entity, it didn't come up with from one source, which was then obvious. You had to connect all the dots you did over this year or more, Christian. I understand this.
To look for one thing that's going to prove it all, it doesn't exist, because if that would be the case, it would be too simple, and the way they're hiding it is they've broken it down to many micro pieces and you got to put the micro pieces together. And they rely on most not to do the research.
Intellectually, I understand, and I had enough. I spent enough hours to think about it, and I share this conviction that our signature is ultimate value in this kind of monetary system.
You could prove it just with the logic, because, all right, if my signature represents everything that I can do in the future, because I can assign everything that I'm going to do in the future to it by my signature. So that represents some kind of value or interest. And my signature controls that. Now, the question is, what is my future labor worth? Well, there's no way that I can say that it's worth any particular value, because I don't know how much I could make in a lifetime. It's really unlimited. The sky is the limit. So you have an unlimited amount controlled by your signature, and your signature being your most valuable asset, because that's what controls all your future labor. It's just a determination of what is your labor worth. Well, I think my labor is worth this, or you think your labor is worth that. But that's not the point. Who controls what the value is? That's the point.
Right.
I'm not operating in commerce. The value is not any numerical value, because that's a limitation. I have an unlimited value, because it's my interest. And my interest can be anything that I want.
Okay, Christian, I understand everything. I'm not challenging this. What I'm looking for really is, let me attempt to explain to you a little bit differently. I'm at the point where I'm not only studying the banking theory and fractional reserve system and all other things, but also the court procedures. And what I'm seeing right now that in the court situation, we have to present facts and support this with the law. And I understand this is at law side, okay? But I kind of imagine a situation where presented with the let's say liability debt bill from the public or quasi-public entity, and I attempt to extinguish it entity way, and eventually I was ignored, and I had to go to the court to equity, right? And let's say I achieved it, and I'm in chambers, and I'm presenting to judge that I did extinguish the debt via my signature, okay? And perhaps judge will ask me, how's that possible? What I can really present to him? Where's the supporting authority? Where's the, let's say, law supporting this notion? And I'm not saying it's not correct.
Equitable assets. If you go to Black's Law's definition of equitable assets, that pretty much explains it right there.
Okay.
Fourth edition, fourth revised, Black's Law, equitable estate. It's assets which is outside the at-law realm that the at-law realm can't recognize, can't see.
So in equity situation, we can rely on the equitable asset as explanation of our actions. That's what you're saying.
Yeah, because it's a whole different. It's between
right.
white and black, or night and day.
Right.
100% opposite.
Right. Yeah, I see what you're saying. In the scenario I painted, that would be a good approach. Okay, I'm just kind of hang on this this idea that eventually at some point it might be necessary for me to explain not equitably how the value of my signature, let's put it this way, and I understand what you're saying. It's not one source, but I still need to see somewhere eventually some information about it, and that's my question.
You're trying to think that you got to go into a court of equity and explain to the judge about how I've got an asset that can extinguish the legal part of the debt. And it's like you're trying to make it fit, and it really doesn't have to, because it's the antithesis or the opposite. It's a minus plus a plus. And when you put a -1 and a +1 together, you get 0. It's just straight math.
I know exactly what you're saying. I agree with you, and you answer how I would approach this problem in equity scenario pretty clearly.
The whole fiat system is a debt system, or a minus. All of commerce is using a debt system or a minus. If there is a minus, there has to be a plus. Has to be.
Absolutely. I see that. But what if judge get in chambers and he kind of not really sharp in equity, let's put it this way. He might still challenge me on this, right? Because we don't expect the judges really be, in full understanding of private equity. Not all of them are.
Look through the form, process, and procedure and ignore that and look into the real substance, and then it comes back down, what is the real substance? The real substance is really whatever I say it is, because I'm really the maker of the contract, the maker of the trust.
Okay. I think you answered my question, really.
Here's the definition on Black's Fourth revised on equitable asset. It says that equitable assets are all assets which are chargeable with the payment of debts or legacies in equity, and which do not fall under the description of legal assets. That right there says that you can't describe this asset legally. It doesn't exist legally. It can't be described legally.
So right there, it's good to answer.
Those portions of the property which by ordinary rules of law are exempt from debts, but which the testator has voluntarily charged as assets, or which being non-existent at law have been created in equity. So they are so called because they can be reached only by the aid and instrumentality of a court of equity, and because their distribution is governed by a different rule from that which governs the distribution of legal assets. That was out of Black's Law, Fourth Revised.
You answered my question. You answered my question. Once you cross over to equity, the realm is different. So authority at law, I kind of look for answering this, asking you this question does not apply. Then I should operate on this equitable asset definition or theory rather than look for other stuff.
Laws in equity, we're operating on laws in equity that would really be substance based on principles of maxims. whatever is fair, just, and right.
But from different perspective, all this commercial remedies movement is relying on the signature as the ultimate value. And if I didn't know about entity and what you just explained to me, I don't see how they can prove that this notion is valid. Let's put it this way. The way you're doing this, going to equity, that's fine. I understand. That's different situation. But I don't see how all this DC ROM can really prove this, and all of them rely on this.
Well, really, they don't have to prove too much because they beat you up with a presumption. Why? It's because your signature's on it. You created the debtor-creditor relationship. You created those contracts.
Yeah.
So who is the source of the contracts? There again, your signature.
Yeah. That's another good explanation from the entity perspective, and DC practitioners don't really see that.
Yeah. For those who want to play in DC, let them go ahead and play in DC.
Right. They cannot prove the signature is ultimate value, even though they really attempt to rely on this. I don't see how that, because otherwise it should be somewhere in CGS or other sources. And
yeah, it's like created the DC realm.
Yeah.
Right.
And I have read American jurisprudence and CGS a little bit, and almost I haven't seen any instance of
debtor-creditor realm was created from a trust. Then that means there has to be two titles, because trust always separates title. And we're only talking about the DC realm, only talking about legal title. And we know for a fact that beneficial title exists in a trust.
Absolutely. I can see how, yeah. I agree with you. I agree 100% with that. Okay. And I think I understand most of it. However, I get another observation or problem.
Signature represents all the labor that you've worked for. Now, maybe that labor you've exchanged or traded for some kind of substance, and all that substance is really held in trust, and that's all the actual hard assets of whether it be property or land that's held in America today. It could be tangible things that you can see, but it also can be intangible things that you can't see, which is an asset. And all that was gotten by, or let's put it this way, better up, it was divided by your signature, and it is represented by your signature, no matter what it is. And all this substance or non-intellectual property or intellectual property, whatever you want to call it, tangible or intangible, is all represented by a piece of paper called the title, representing the real thing. And it's on a piece of paper so you could put it down and record it, the act of maybe its creation or its transfer. So it still has to have a signature on there to make it valid. Why is it always has to have the signature?
And the relationship is not really clearly expressed, it's implied, so they see it as DC. But we might turn this into trust the way it really is. That's how I see it, by expressing it. And I think that's what you're saying all the time.
I don't think many people are going to get a whole lot of eye-awakening experience from NT2 or equity or all that stuff, because they're too caught in their own realm to see there is a bigger box, a bigger sandbox to play in, or a bigger world, or even if there's another realm out there that they aren't even aware of, because they're too caught up in their own pet peeve or their own thing that they've spent 20 years trying to perfect, or they've spent a lot of time in, and they just don't want to chuck that.
Yeah. It sounds like you'll get over this frustration you had a few months ago, because I've heard you to be a little bit frustrated that people not really going too much forward. But I guess we all have to accept that not there's no chance everybody will see the trust in
Right.
what we're doing around us.
Well, not everybody's going to see the trust. Not everybody in D.C. is going to be able to see it and switch over.
Yeah. And not
Plenty of
even
people who
everybody
are
in this movement.
and want to switch over, and those are the ones that I'm going to teach and take farther. It's not up to me to convince somebody and get them crossed over. I don't care for that. That's not my bag.
Absolutely. And I tell you this, I mean, I'm glad you're accepting this, because if in a few years this foreclosure thing will be over and student loans bubble will burst, there will be less of us.
I really don't care if anybody follows me. As far as I'm concerned, I'm with everybody else. You know, I'm doing this personally because this sets my mind free.
Yeah. So
I don't really accept anybody else.
So that's good.
I mean, I have in the last year grown exponentially on a concept that nobody has seen before. And believe me, I'm probably going to take a lot of flack for that, because people are going to argue it and say they just don't see it. Well, hey, that's their choice. You know, I can't help that. But a lot of people do see it.
Yeah, absolutely. Entity, absolutely. The entity is great. It's amazing. I mean, it really changed the way I'm seeing work around me. I mean, last time I opened the account in JP Morgan Chase Bank, and it was like 2 months ago. They accepted my signature by grantor and my name. I had no trouble to opening checking account, 2 checking accounts, one business account, which I had to unfortunately do, and one personal account, you know. And I've got another question to you about that. Is there any purpose right now to mark on those checks non-negotiable?
You
didn't study enough of it.
As non-negotiable, and then try to use it as a check because you're trying to negotiate it. But that's the whole thing. You're trying to use the DC realm, the commerce way, and if you use the commerce way only works the way commerce is set out to be working.
Right. Because negotiable. I'm transferring this. This
non-negotiable
right.
deposit. Once you negotiate it, you just turned it into a negotiable instrument.
Right.
I
see what you're saying. I understand this, Christian. Great. Go ahead.
But here's the thing. You're trying to go in the front door and create a trust account or a special deposit account, and that's the DC door. You need to go into the back office. You got to do the back office banking.
That's why I'm studying banking theory. I think there is a chance I can see a little bit clearer the things I didn't see before. But you know, I'm not trying to go front way. I simply wanna qualify my signature as often as it makes sense. Okay.
Yeah. If you get the back banking door open, and you'll see a realm in there that is like unlimited, because they're doing it.
Look, I would like to have access to this back door, but it seems like I can find it yet. You know, I guess I'm not long enough in this movement to really know enough to see it, to understand it fully. That's why I'm taking a little bit step back and going to banking, understanding more banking, and perhaps.
Banks today on the front door do not understand special deposit. They look at you like, what are you talking about? You must be nuts. I never heard of that. And I've been here 20 years, they'll tell you. I know that for a fact. Because they don't know it as special deposit, although it's right out of their banking handbook. They know it as a trust deposit. Now the question is whether it's a trust deposit on the front office or is it a trust deposit on the back office. And if you go in the front door and say, well, I'm going to set up a trust account, which is really, you meant a special deposit. Well, if you went in there and said a special deposit account, they'd look at you and I don't know what you're talking about. We don't do such things. And all trust is in their name, the bank. But when you tell them I'm going to set up a trust account, they say, oh, okay, well, you got to go down to the head office downtown and talk to so-and-so to do that.
And they won't talk to me. I know I should try that, but it's kind of didn't really consider it because I don't think I'm ready. You know, if they will challenge me. I don't have enough knowledge to really talk to them like I know what I'm talking about. You know?
Okay, well, you answered your own question then, yeah.
Yeah. So that's why I'm kind of
go in there and talk and walk the walk, then there's no way that you can exude that confidence, and they can recognize that in 30 seconds.
That's, I understand this. That's why, and I'm longing to have full knowledge of what's going on in banking and entity and this trust field.
Well, let me tell you, it's going to take a lot of hours, believe me.
I got a lot of hours already behind me.
Yeah, how many hours that's going to take?
I do. I've been on this course since March, I guess. So, and I'm studying something else along the way, so I'm not sleeping at the wheel.
It takes at least 1,250 hours of study to get to a point to where it's starting to understand it. You need another double that, 2,500 hours total, to really comprehend it. And then it goes from there. And probably to get all from the A's to Z's of everything you want to study, like really I've tried to turn over every rock that I can turn over and look at it, analyze everything. To get to that point, you're talking 25,000, maybe 30, 35,000 hours. I mean, I haven't kept track. Night and day study for years, non-stop, no time off, night and day, every day, I mean. That's why believe me, there are people out there that know me.
Yeah.
Back that up. But, not many people can make that sacrifice.
I don't see how I can live for the rest of my life not attempting to understand this. I mean, I stumbled on this movement like 2 years ago, okay, and I was lucky enough to find Greg on the way, and then Jerry, and then obviously you. And once I'm here on NTT, I don't see how I can go somewhere else. But I still know that this what you're saying. Sometimes there is no shortcut. I mean, the way I see it really is that you paving the shortcut for us. I mean, it's almost like you're giving us the paved way. But it's still not easy to
all
walk
the hours
this way.
separating wheat from the chaff, and I'm giving everybody just the wheat.
Yeah.
So they don't have to spend all the hours that I spent.
It's not easy to walk this way. It still needs an effort.
We're not just sticking to one thing. We're really examining the whole Palanthra from A to Z, and here we're just trying to apply NTT, and next thing you know, we're talking about equity, and we're talking about the courts, and and this is not a quick fix. This is a life study.
Right. And the knowledge has to be complete, not just in one area, because if you don't know at law procedures, you don't know how to get to equity part of it. So it's still,
The king knows to run his realm. He doesn't rely on somebody else to tell somebody else to do it. He knows what to tell that somebody and tell them from there. So the king has to know everything if he's going to be really in control of his own realm. And there's really only two realms. There's the private realm and there's the public realm. And what we haven't been trained all our lives is the private side.
But then there's one more observation I want to share with you, and I don't know if you agree with me, but I feel like those trustees were like a public figures which would send us bills, and we want to make them into trustees to extinguish these debts. they don't really have a real incentive to pursue this. I got a feeling that it has to be somewhere some kind of penalty for them to be clearly seen to really perform, because otherwise they will be only compelled by court of equity, and they're risking nothing to really fulfill their duties. Do you know where I'm going with this?
Yeah, you're talking about enforcement.
Right. If they feel that they can go, let's say, to prison for 3 years, okay, then they will be more willing to compel, But if the only risk is to go to court of equity, and the court of equity will instruct them to fulfill their duties, and they do risk nothing, there is, it's much harder for us and no risk at their part. What do you think about that?
Well, listen, my friend, that what we're going to be releasing in the future might be so powerful that most people can't handle it. Because what it is, the enforcement boils down to this, that you have the power to terminate everyone commercially. And I don't mean you're going to kill them physically, but commercially, they do not exist. That's the power that you got.
Okay.
That is ultimate enforcement. Because I make you commercially dead that you can't function for the rest of your life because you do not exist in the commercial realm. I put you in a world all by yourself that you are beside yourself for the rest of your life.
It's amazing. You have the answer to all my questions from the angles I never expect to hear the answer. Yeah, that's the way. Yeah.
Look, I'll give you a chance to do this because you know, at least your bosses know, that this is the way it's done. It's done this way. Now, here's the chance to do it. If you don't want to do it, well, we'll go upstairs and we'll just terminate the whole thing commercially, and then you can be in Never Never Land for the rest of your life.
Okay.
You do that to a couple people, and everybody will realize, hey, these guys are not the ones you want to mess around with. These are the true sovereigns that are running things. They are now at the age of majority. And then we can get rid of all these shackles of bondage and slavery that's enslaved everybody, But I don't think a whole lot of more people are going to get that. They're going to abuse the power and mess it up, and they're going to end up being more hurt than what they were if they would have never just even done it. But anyway, that's another thing.
Great. Well,
but with that kind of power comes a equal or greater responsibility to use it. To use it equitably, under equitable, God-conscious mind. So that's all I want to talk about that.
Okay. No, it seems like this is lacking, but I know now that it's not lacking. It's simply not for everyone. Okay. So you're answering my question again. Not everyone is responsible enough to really get this power.
Right. They're not.
I can see that. Okay, Christian. You answer my questions. I got nothing more at this moment. So,
okay. Appreciate talking. Haven't heard you for a while, so.
I'm sorry?
I say I appreciate talking to you. I haven't talked to you for a while.
Yeah. I had internet problems and then virus problems, and then I had to go back to my old country to visit my mother, which I haven't seen for a while, quite long. Actually, now I'm back here, and unfortunately I have to prepare for my tax court fight, and it stresses me a lot because what I really want to study is identity. But oh well, I have to do what I got to do.
IRS to settle your tax problem.
I'm sorry, again.
Have you used the private side of the IRS to settle your tax problem?
You see, that's the thing. I attempted to do something, and I nominated him and her. You know who I'm talking about my previous tax liability. Recorded already, but it seems like not much happened. And this thing I'm fighting in tax court is, but the way I understand the process, it's proposed tax liability. If I lose, they will be recorded, and then NTT is the way for me to go. Okay, but I chosen not to let them record this tax liability. Okay, because then, it will be perhaps easier, but perhaps not easier. Perhaps much easier for me is to go to the tax court, and I feel really good that I can defeat that notice of deficiency and not let this liability be recorded. Okay, rather than attempt to extinguish it. That's the way I understand the process. Okay, because I know they didn't record this notice of deficiency liability. It's proposed. So it's like,
where'd you send the documentation to?
I sent to Washington basically, but I know that they were rerouted to Ogden. Okay, like I've heard a few times on the call. But I don't see any positive action going yet. However, I did not really finish the process with UCC1, UCC3, and eventually county recordings, and I didn't send them notices of it or copies of it. So
that's my guardian-ward relationship.
Sorry, say again.
Did you terminate the guardian-ward relationship?
What I really did, I turned this into I sent an indenture in special order, and
unless you terminate the guardian-ward relationship and it no longer exists, that you're no longer the infant, the guardian has control over you, then you really don't have the authority to do any business for yourself because you're still an infant yet.
Mm-hmm. Are you talking about this change in the individual master file thing you were talking about before? Or? Yeah,
we've talked about the guardian-ward relationship on previous calls. In fact, there was one call that was dedicated solely towards it. So that's the one you need to go back and review.
Okay.
To utilize the private side, you got to have the authority to utilize it, and an infant doesn't have that authority. Okay. Only somebody who has attained the age of majority has the authority to utilize the private side.
Do you have an idea what call that was? Or perhaps Lisa will know.
Yeah, I don't remember which one it was.
I think that Eric was reading out of CJS. Was that the one you're referring to?
I think he's reviewed something on his own based on that show, but I forget what date it was that I did that. It's one of the ones that you could get from Lisa. It's on the list. It's the high point.
Okay. I definitely look into it. Great. Great.
558 was Nature Deposit, I believe, and it was either before or after that. So it's somewhere around about 5 of, either
but
May
you're talking about May calls? like May 8th, May 18th?
Yeah, it was one of those.
Far back?
May or June. I forget exactly which one.
Okay. All right. I attempt to look into it again.
It's not one particular thing. It's a group of things that we've gone over in the past, all combined together, working as one.
I know there are many important calls. I kind of had a chance to review them, and 508 is a special deposit discovery kind of call, and 518, I think it was about guardian water relationship. I think. I've listened to those calls. And a few others important ones too. So.
Skype Faith to Trust, and Skype is down. So anyway.
All right. Okay, Christian. Thank you all for talking to me, and I guess Merry Christmas to everybody.
Uh-huh.
Because and I never congratulated you 1 year of entity. It's kind of important day for me too. So thank you for bringing this entity to us.
Well, I'm looking forward for another year. Where we're going to be next year.
Oh, I will be here for next year too. So I'm waiting for it.
Okay, appreciate it. Thank you.
Thank you. Okay, bye.
Jeff, you're unmuted.
Hey, Kristen. Can you hear me? Hello?
Hello.
Hey. Is that better? Can you hear me now?
Yes. Uh-huh.
Okay. Yeah. That was a great call there. I think that guy just looked at the definition of equitable title. He'll get his answer for the authority. Equitable asset and equitable title.
Yes. Uh-huh.
Can you hear me?
Yes, can you hear me?
Yeah. Can you hear me? Am I coming through?
Yes, okay. Go ahead.
Okay, yeah, what I said was if he looks up equitable title, he'll be able to get the answer for the authority of how we have the ability. If there's a legal title, that has to be an equitable title, essentially.
Yeah, you probably could do some study in CJS and look up under estates.
Yeah. And then, the enforcement is basically filing a breach of trust. That's the whole beauty of it. There is enforcement by filing a breach of trust. That's how we can enforce it. It's really great. That's fantastic.
Right.
So, I guess what I was calling about was, I've heard you on calls saying you could go back and express the trust on even cases that have been closed. Am I understanding that right?
Yeah. Mm-hmm.
Even if you've used something like an attorney, you could go back and correct the record by expressing the trust and sending the indenture and the res and saying, that was...
The case never terminates because the case is always open because you never can pay it.
Right, so those bonds are always out there.
Because if you actually paid it, you would have merged the titles because you would have merged the two estates together, or the two debt title with the asset title, and it would have terminated the account.
Right. So you can really...
We're being tricked to just operate with just the at-law side or just the legal titles, and we're borrowing, and stealing these legal titles and passing them and signing them and using them as money.
Right. Yes.
All the debt titles.
So my cases are just really lodging pecuniary liabilities against that asset account.
Yeah, they're promises. Hey, get it paid when you get real money back. But nobody's getting the real money, which is the equitable asset, merging it and terminating it, which we get.
We got the privilege and benefit of using our signature, so let's use it.
Now, we've been brainwashed or psyched out or smoked or whatever you want to put it for so long. Ever since the Lords have been in by his cheek, they've been trying to do it to us.
Yeah, really. Pretty amazing. So, okay. And then also, you said it really doesn't have to be any particular kind of document for the trust, right? This essentially could just be the claim in your signature, a blank piece of paper. It doesn't even necessarily have to be the charging instrument. Is that correct?
Well, I would use the case number.
Yeah, case number.
I could make up a title using the case number.
Right.
The whole thing
so,
is case.
Yeah, so how about the idea, at one point you were writing this was a long time ago, about writing a non-negotiable instrument out of the actual charging instrument. I don't think that's more like DC concept anyways. Just non-negotiable claim. Doesn't have any value, equitable value, unemployable value, right?
Yeah, as long as the claim was turned into an equitable asset, you could use that then as a special deposit from it then.
Yeah. Sorry.
But once you swallow it up with the greater, which would be the plus side, the minus side no longer exists. The only thing left is the plus.
Right. Yeah, I always thought it was a good idea to use the charging instrument because that way you've got really a physical example of the merger. You sign it right over, you put the claim and your signature right over their claim, their signature, whoever trusts.
It's coming in to when you start getting NTT and you understand it, and instead of just going after the case, you understand how to go after the case, but you understand you want to go after the proceeds.
Proceeds, of course.
Where the real money is that they're using to operate with. That's
right.
where astronomical amounts are.
Yeah.
It's just the value of the case itself.
Right.
Case worth $250 for a traffic ticket, or say $1 million for the case itself. You're talking about $6 million, $60 million, and $600 million at least on the background of the bonds. And that's just the beginning of the chain. What else is attached to that as a derivative, which is a proceed therefrom from your signature? Now you're talking about where the real money is that they're operating with, and if you understand how to get the case, you should be able to get the proceeds. And if you start closing down the proceeds and merging the proceeds and bringing the proceeds to zero, then you don't have any commercial value for them because you know how to come at whatever their offer is for the commercial value and zero it.
Right.
How long does that take before they leave you alone?
Right. You want to trace the bond. You want to trace the funds. You want to do an audit trace.
The money trail. And the beginning of it is just the case.
Yeah.
That's just the start. And you'd probably be surprised at the astronomical amounts of money that they've formed from the derivatives off of your signature.
Right. Court is nothing but a big bank.
Down.
Big old bank. Pretty amazing. Okay. I think that's it for right now. I found some books. I've found some interesting books on trusts. At the library. I haven't had a chance to really go through them, but I'll bring them back up on the next few calls. A lot of real estate trust information in there. So.
Older ones or newer ones?
I haven't really had a chance to look at the date. Did you actually get to see the scans I sent to Faith?
No, I haven't.
Actually, I sent them to your email. I believe I sent them to Moving Titles. There were scans of the transfer caused from that law to equity. Yeah, and there was, I didn't have any way to Skype them for some reason. They weren't Skypeable. But I sent them as JPEGs and PDFs. And there was also another one for asking for a search, I think it is, or what were they called? What's that term? The equitable, like a judge, oh gosh, I forget what it's called. You know the term for a kind of a specialist in equity. I forget, we were going over that term. There was a term for a judge. I think it's a master, isn't it?
Yeah, the master in chancery. Yeah.
Yes, master. Yeah, there's some pleadings for that too. And I was thinking that would be a good way to. What's that?
Master of the role, but I think they just call them masters here.
Yeah, masters in equity or masters in chancery. That might be a good way to go after those bonds. Appoint the master to do that.
Well, you could have the court appoint a constructive trust, and because it's being held fraudulently, and trace it and have them put a tracking or tracer on it, and appoint a receiver over it for doing it.
Yeah. Okay. Yeah. All right, Christian. Well, thank you for your time. Happy holidays.
Okay. Thanks, Jeff.
Okay. Bye.
Nobody else got a clean board, so anybody have a question, press star 8. Star 8 to ask a question, anybody? Star 8 to raise your hand, state your name, where you're from.
Hello?
Hello, who's this?
Hello?
I can hear you. Who's this?
Oh, hi, Christian. This is Monica. I have a question for you. I did a filing of a UCC1 registration of a bond for a case where the plaintiff had received a judgment. It was a confessed judgment for a private lending loan. And so I did the one naming the clerk of the court as the debtor. And then in the box 4 gave constructive notice of security interest lien in the commercial registry with a certified mail number. And then, noted the bond and the bond number and the value with the form 56 and the case number. And I did the indemnity bond to, just pretty much pay the debt, which was worth 4 or 5 times more than, what the judgment amount was. I received a letter. First of all, I saw that they weren't doing anything, and the bonds were showing up on record. And so I called to the court and I said, why is my, private process being, displayed in the public? This is protected under trade secrets. I, put it, in confidentiality and so forth and so on. So the guy said, well, I'm going to go ahead and I'm going to pull it and I'm going to, send it over to a judge to see if we can get it taken off the record. Okay, then I received a letter from the judge that says this matter comes before the court on the defendant's courtesy to inform you, Peggy McGee, clerk of court, that on the 25th, a bond was registered with the state of Maryland along with the 56 appointing U.S. fiduciary for the purpose of settlement and closure of the case. The court has reviewed the documents filed and finds the documents not properly authenticated, nor can the clerk serve as a fiduciary in any case before the court. And he ordered that the defendant's bond is hereby stricken. Now, the bond was sent to them with 72 hours in which they had to, bond or rebut.
Are you doing NTT?
Say that one more time.
Are you doing NTT?
You talking about with it?
No, are you doing NTT process?
I thought I was.
Everything that you told me so far is all debtor-creditors, not NTT.
Oh, okay. So when you appoint them as fiduciary trustee, that doesn't remove it?
Anybody fiduciary trustees using Form 56s. We don't use any bonds like you're touting. We don't file any UCCs with debtors and creditors on them.
Okay.
Debt is non-NTT. It's all debtor-creditor. You're doing a commercial redemption process, not NTT.
Okay. Well, I'm new to the process, so I thought, what I'm saying, I was on track. Okay.
We don't create bonds.
Mhm. So you just claim the case and then just appoint them as trustee.
Appoint who is trustee?
Whoever the offending party is, so that you could collapse the trust.
And how do they become trustee?
Whoever the trustee is the one that is obligated to pay the bill. So
no, I didn't ask. I asked how did they become trustee?
By your appointment under. See, I don't know your process. I'm just learning. Okay. But I would assume by the appointment of expressing the trust under the Form 56.
Well, okay, that may be a fiduciary appointment, but that might not be a trustee appointment. See, a fiduciary is not the same as a trustee. A trustee can be a fiduciary, but a fiduciary might not be a trustee.
Okay.
How do you form a trust?
By expressing it, by writing it, I guess. By appointing within a declaration.
Okay, what are the necessary elements to form a trust?
You would need the direction for, what the trust is set up for and what the trustee is supposed to do and who the trustee is and who is the beneficiary.
Okay, you're missing some things. Do you have Gilbert's law summaries, the one on trust?
Yes, I downloaded it. Mm-hmm.
Okay, in there it's got just about all the information you need to form a statutory trust, and a private trust is not much different. But you've got to have the necessary elements and the method of formation, and you're missing some things, and you do not have a valid trust. First, you have to have a valid trust, and you've got to be able to express it. And you're not appointing a fiduciary on a Form 56. The trust is formed upon the res being placed in the hands of the trustee. And if you didn't have a valid trust and you didn't have valid trust res and you didn't put it in the hands of the trustee and you're trying to do all this stuff under the commercial realm and you got all kinds of stuff that you're mixing apples and oranges, and what you're doing is nothing more than the DC commercial realm stuff.
Okay.
And you need to go back and start on the 11/7/2009 tape debut of NTT and get a hold of the highlighted tapes from Faith to Trust, and start with those 11/7s and go forward.
Okay. Okay. Thank you. I appreciate that.
All right. Thanks for coming on. But it's it's in the old audios, and that's where your research is to catch up to where we are now.
Okay. I'll take heed. Thank you very much.
Okay. All right. Anybody else have a question? Press *8 followed by 1. Or no, it's not followed by 1. Excuse me. *8. *8 to raise your hand.
Hey, good evening, old buddy. How we doing?
Good. How about you? Merry Christmas.
Oh, yeah.
Holidays.
Holidays. I was wondering, the one Jen who was on, I think, just before this lady, he was speaking of some real estate contracts. I was wondering who that was and if there was a way to talk, get with him. And the other thing was, you mentioned two parts tonight that were, one I think you did reread, and the other one, I think it was part 1 of 61 or 62. I was wondering if you could read that and go over that. It was right after or right with the special power of trustee.
Yeah, I would want to read that myself privately and think about it myself and then go over it again. Because from just reading it right there real quick, I see some things in there that could be some possibilities.
Right. Okay. and the first one, or that act of 1883. Was it Section 51? I think it started.
Yeah, there's a lot of acts in there, but I think which one it was, 1883.
Yeah, I was wondering. I didn't really get exactly what that was.
A lot of those they're referencing are the ones that were made in England, and since our trust laws are based on English to begin with.
Right.
But since it was 1776, and since then on, we've formed our own jurisprudence on trust.
Mm-hmm.
But the English is the base or the foundation of it.
and I know we were talking about the Fem Cover.
It's like before 1776, it's English based, but then after 1776, it's American based, and that would be the next thing we're probably getting into would be like Bogarts on trust, or the they called the encyclopedias of law, because those were the forerunners to the Corpus Juris, which was the forerunner of Corpus Juris Secundum. So actually the body of law is the encyclopedias of law before they started coming out with the Corpus Juris. And then they added Corpus Juris Secundum.
And then even not as quite as astute would be the Amjurs, right?
Yeah, Amjurs follow along on a parallel with similar information that's really the same. But as progressing along, we've laid the foundation from the start, because Lewin started, when trust began, and that was like for uses, and then uses was changed into trust. And we've explained the history and talked all through it in this Lewin, and now we're coming up into a more modern time, like right around 1776 times. And then when we finish Lewin, we'll probably get into Bogarts, which will pick up in 1776 and come forward into the early 1800s or later 1800s. And then we'll probably go into CJ, and then we've talked about CJS. So now we're filling in the gaps. So we're putting we're going through a total history of trust.
Right.
Now what's more pertinent to each and every one of us is how it's operating in this country and how it's operating.
Yeah, hardly anybody knows.
Yeah, we just haven't quite gotten there yet. We've gone over Gilbert's, but we haven't, we've gone over CJS, and we're now really starting to get into the pre-33 stuff, which would be Corpus Juris and Bogarts, and we haven't got there yet.
I heard you mention the hereditaments and the residuals tonight, and I guess that comes all back to the remainder man, right? Or I guess I wrote that down myself.
Yeah, remainder man, beneficiary, third party.
Right. And how do you think we distinguish, say, the grantor and the beneficiary, distinguish them, without letting them seem that they're one and the same.
Which one and the same again?
The grantor, settler, and the beneficiary, or even the executor. All that. Being.
Yeah, you can be all three parties, but you can't be all three parties simultaneously.
Right.
You make trust.
Right. Well, I don't think I want to be hardly ever the trustee until
What if a trustee outside of court say I can make payments as trustee and make actually merge, but acting as payment. And then if I was in court, then I'd want to be the grantor beneficiary instead of grantor trustee.
Right. And the hereditaments, that's just all the things that are that can be inherited, right?
Yeah, that would be the estates. Yeah.
The estate, right. And what else did I want to ask you? Oh, there was talking about a daughter or a sister, and they were talking about Fem Covert and coverture. I didn't quite get that. I guess as she was an infant or considered an infant, you know.
Well, that was a covenant. It was a stipulation that the party had to be married, or they had to be 21.
Mm-hmm. And that was the coverture of the covenant. Is that it?
Yeah, in that particular indenture, yeah.
And I know you were talking about special appointments or specially appointed. And you know, I've got to come up with a notice. Notice of preservation of interest, and publish it. And so, you know, I was going to say by operation of law, and now that somebody mentioned something that, you know, this is a self-authenticating document, and all else, you know, and any statute contrary to, notwithstanding. I don't know, what else do you think I could mention along those lines? And then, you know, in general, in special, in general, but being special, so to speak, you know.
What else could you mention for what purpose, using special?
A notice of preservation of interest, or right title and interest, and or claim of right title and interest, proceeds, residuals, remnants. I'm just trying to do this for the estates of my ancestors.
I don't understand. For
to make claim to it, and so.
Okay.
So as you were mentioning, so they don't have the benefit of abusing mankind with those proceeds and all, you know, because that's exactly what they're doing. They're abusing us and the rest of the world with the proceeds and those you know, and the interest and everything from those.
Right. Yeah.
Well, the deals are read.
Lord over land. Make yourself lord over your land. And that would be through the withdrawal and the redeposit. Because that's going to switch from being the debtor or the defendant or the trustee as the slave, withdraw from that, and then redeposit as special, and that's going to redeposit you as beneficiary, which is the lord over the land.
So do that
each case individually, or you could do it all at once.
Yeah, that's what I was saying. I'd do it all at once, and that would be my signature, all the other ancestors' estates, and that would be their all capital name, and on
a microcosm basis, just for each individual estate, let's say, or each individual one, that would be, that's a lot easier to do than to go after the whole thing.
Yeah, I know, but I'm limited on the time. There's something came up that I just happened to notice, and I think it was a blessing, you know, the divine intervention there that got my attention that somebody mentioned. And if I don't get this out by tomorrow or the next day, then I'm going to lose, or I'm going to say lose, but that opportunity will have. Well, yeah, I'll lose that opportunity, or I'll lose my, you know,
the only way to lose an opportunity is because the limitation that they're giving you is going to run out is statutory.
Right. That's exactly it.
And what makes it statutory is you're acknowledging the debt instead of acknowledging the trust. If you acknowledge the trust, that stops the limitation or the running of the prescription, and that way there is no limitation. So if there is temporarily, you might be able to try, tell them you want an extension of time for the limitation.
Well, they've got a statute they're passing and going into effect, to January 15th. So like I said, I was going to make a publication, 4 times, and I got enough time to do that before that happens, as long as I get it in there, before the end of this week. Get the publication started by the end of this week. And after January 15th, they're sealing off anything unclaimed.
Well, that's what they say under statutes, but statutes and codes don't apply under trust, so under private trust. That's the thing. It's always there available for you to get, even if they close the door on the ad law side. I'm not coming through the ad law side.
Right.
The ad law side is inferior to the superior equity side or the trust side.
Right. I'm just saying, that's going to make it that much more difficult to get the, to get that.
But what they're really doing is they're locking down the public side to where there is total slavery in the public side.
Exactly. So that's what I'm trying to,
But you got to remember, we don't operate on the public side.
I understand, but then don't we have to access both sides?
I'll have to gain control of both sides. I don't access that public world. I control it.
Well, yeah, but if they do that, aren't they going to be trying to control that and keep us, out, sort of lock us out?
Yeah, but that's okay. They can try to lock me up, but they can't because I'm not coming in from the public side. I'm coming in from the private side, which controls the public side.
Right. I got you. I'm just trying to avoid, down the road.
They can do whatever they want in that public realm. I don't operate in that public realm. They can have that public realm. They can do whatever they want with that public realm. They can blow it up as far as I'm concerned. I don't operate there. That's the question, how to stay totally private. And then once you are private, then not to operate in such a way that you commingle or breach it, and you're back in the public again, and just negated everything that you did.
Yeah, and what is this? That really gets me. I tell you, I can't. Hard issue for me. I don't know.
I ask people out there for what they're trying to do is way above their means and knowledge. And they need to start on more baby steps, and a good place to start with a practical application NTT would be go out and set up a checking account that's, say, a statutory trust. Go form a Taunton Trust with a bank.
What kind?
A Taunton Trust.
The Totons?
Totten.
Right.
And that's Gilbert's also. They talk about it in Gilbert's. Just go out and get some experience setting up a Taunton Trust with a bank, with a checking account. And this will start cluing you in on how to operate under a trust, even though you're operating under a statutory trust, but yet you still start getting some kind of feet wet, some kind of experience on a formation of a statutory Taunton Trust that gives you a beginning understanding on how to operate privately.
Okay. All right, I appreciate it all. You know that. And I'm going to leave to my best. And Almighty bless King protect. That guy with the real estate contracts, is he, you know who that is? Or is he a regular? Pardon me?
I don't know who you're talking about. Real estate contracts tonight?
I think somebody was on mentioning it about real estate. I think 2 or 3 people before I got on.
I don't know. I didn't get that.
I was talking about real estate. Okay. I'll let somebody else get on. I appreciate everything. Almighty bless.
Right, thanks, Chris.
And hope to see you sooner than later.
Okay.
All righty. Thank you. Miss you all.
There's nobody on the queue line, so anybody got a question? Star 8? Star 8 to raise your hand. We've got about one more question we can take. Star 8 for anybody who wants to raise their hand for a question. Star 8, question anyone? Star 8 to raise your hand, get in the queue line. State your name, where you're from. Anybody? Star 8, going once. We'll call it a show if not. Okay, we got somebody that's unmuted. Hello, caller. Can you hear me?
Yeah. Wrong button again. How you doing, Kristen?
Hi, Albert. Hi.
Interesting call tonight. I have one question for you, and this deals with Trust Res. And I understand that Trust Res cannot be altered. So when I send in my Trust Res, and would it be best for me to say, I think we spoke one time about having a sheet of paper on top, sign that rather than the Trust Res itself, and endorse the back with another sheet, pin them together. Would that be better?
Yeah, that way that separate sheet is your res or your special deposit, yeah. Rather than putting it on an angle on the top of the documents.
Does that sound better than altering the Trust Res? Is that what you said?
It functions the same way. It's just a personal choice which way you want to do it. There may be times maybe one might be better than the other, though.
Well, since I don't know, how, say, the trustee would want it, maybe that's a good choice. And just leave it open if they want it signed, endorsed in the back, whatever.
Well, there's cons to each one. If you put the Trust Res on top of the other one, you've actually, merged it, and it looks more merged that way because the thing on top takes precedence over the thing underneath, and the thing underneath is the debt title, and the thing you put on top, which was the equitable asset, the Trust Res, and you merged it. But you could do it with a separate piece of paper and then just incorporate it into a separate thing with an instruction on the special deposit that works the same way as that, but it's spelled out in words.
Okay. Well, see, now you gave me a much more clear picture of what I was studying earlier today. And I remember you speaking about this very thing, and I just wanted to make it clear.
Yeah, because actually the Trust Res, what you're doing is you're putting your signature on that blank piece of paper, but you're creating an equitable asset title, which is the Trust Res, and that's what you're going to merge in the special deposit instructions, and telling them that's what you've done, and ordering them to, ledger the transaction that you've done, or not the transaction, ledger the merger that you've done.
Right, and in the instructions, I guess I'll explain what I'm doing and what I want them to do.
Yeah, because actually you're the one that really merged it, but you're instructing them to, since they've got the accounts, to you're creating an account with them as trustee, and they're really like the accountant, and you're telling them to, perform the duty of the accounting and come up with the zero on the account.
Great. Am I sounding okay today?
Yeah.
Okay.
If the trustee has a duty to account, then if he doesn't do the accounting, then he doesn't zero the account, or because you've already merged it, then that would be the breach of the trust.
Yep, it's going to be interesting to finally do that and see what they do about it. I guess everybody has that little itch, with their trust res and whatever venture they're doing is the response. But it's always, in fact, it's the best thing to know is what you yourself are going to do and how you're going to defend it, if you must. Well, I think you were just about to close up anyway. Thank you, Kristen. You made it clear for me.
Okay. Thanks, Albert. Yeah.
See you later.
Anybody else? No? Okay. I think I will call it a night. So thanks for coming on, everybody. We'll see you next Saturday. If we have a show, it's kind of up in the air yet or not, so I don't know if we'll be on or not. If we're on, we're on. If we're not, we're not. So everybody have a Merry Christ Mass, and if not, for sure we'll see you on Monday. Night all.